You may proceed when ready.
Waiting. Okay. Okay. Good morning. I'm Wendy LaQuasto. May it please the court. I'm here today representing appellant George McDaniel in an appeal from an order that entered summary final judgment. I'd like to reserve 5 minutes for rebuttal.
All right.
Okay. This case presents 3 issues. The first issue is the primary issue. It's the entry of the summary final judgment, and I'd really like to focus on that in my oral argument today. We contend in the first issue that that Super Discount Pharmacy did not satisfy its burden of conclusively proving there were no genuine issues of material fact so as to be entitled to summary judgment. Particularly, we feel that there are issues of fact as to whether the prescriptions that were filled were unreasonable on their face and whether they were verified by the pharmacist Bloom. I know the court's well aware of the summary judgment standard, but I think nevertheless in this case, it's important to articulate it as we start to consider it, because this is a case in which the summary judgment standard has been flipped. And so I think it's really important to look at the case in that way. The summary judgment requires the moving party to conclusively prove a negative, the absence of any genuine issue of material fact. The moving party's evidence is to be strictly construed while the non-moving party's evidence is to be liberally construed. If the record raises even the slightest doubt that there's an issue, then summary judgment must be denied. And importantly, summary judgment is not a substitute for a trial, and rather it's a determination about whether there's triable issues. So with that said, I think that I don't think there's any dispute either that there is the pharmacy owed a duty to Stephen McDaniel to fill his prescriptions with due and proper care. McLeod, Sorensen from this court, Olekna, Powers, and Dee all say that. And they also say that if a pharmacist fills a prescription that's unreasonable on its face, that can be a breach of the standard of care. So we maintain that there's triable issues on 2 really important facts. And the first one is—
Ms. LaQuasto, can I ask you a question? My recollection is there is testimony that there is a therapeutic reason for that combination of medications.
I'm sorry.
And one of the pharmacy experts testified that despite his position, others might disagree with him as to the therapeutic purposes.
I'm not sure that I heard the entry to that question, but are you asking me whether Dr. Doran said that reasonable people could disagree about the therapeutic use?
I thought that was part of his testimony.
Well, he did say that that there is leeway for reasonable pharmacists could disagree, but that doesn't mean that there's no standard. And that kind of hooks us into the verification aspect. You know, they have maintained, Super Discount has maintained that it verified the prescription with the prescribing doctor, which is the only way that you would know the therapeutic aspect in this case. And yet there's nothing to prove that. You know, they've said that the name Bloom is written on the prescription, and Mathrew said that shows that he called the physician, but Mathrew testified in his deposition that the proper procedure for verification would include the words verified by, and then the name and the date. And these prescriptions don't say that. And plus, the only 2 prescriptions that are here are the ones for May 2011. So all the other prescriptions, and there were several of them over a course of 2 years, none of them are shown to be verified. So maybe there could be a therapeutic use for this, but that creates a fact question because we don't know this verification, because we don't know that. That's the fact question that we have. Maybe the evidence will show that, and we'll get booted, but maybe it won't too. And I don't think, and that's the problem with this case, is because it seems like it became a trial. Anything else on that? Okay, thanks. Okay, so you kind of jumped me in, but jumped ahead of me a little bit, but we maintain that there's genuine issues of material fact as to whether the prescriptions were unreasonable on their face, and also as to the verification. And as to the unreasonableness, that's unreasonable as to frequency, dosage, combination, and the quantity. The trial court found that there wasn't any genuine issue of material facts on the fact that the pharmacy met its duty to use due care. But in doing so, the judge said on the record, she was relying on the facts in Super Discount's motion. And I'll direct you to, it's the supplemental record, 3379 through 80. And also at 3361 in the supplemental record, she also assumed that there were only four prescriptions at issue, because that's what Super Discount had said. But Dr. Doring said it's the whole 2 years. Those 2 years of prescriptions created a situation where he would be more prone, more propensible to becoming addicted, and that all of those prescriptions were unreasonable, and all of them, in totality were unreasonable, and all of them contributed to the harm because they made him more prone to being addicted. And
but there's no evidence that the deceased presented himself in an addicted state, such that a pharmacist would know that he had a problem.
I didn't see anything. I think that there was something said in the record, like there was no showing that he was disheveled in any manner, or that he looked like he was, addicted, or, inebriated in any way. I think that there is record evidence that says that. But it's also important to note that a Super Discount has his history. And on pages 3 and 4 of my initial brief, I list all the prescriptions that they filled in that 2-year period, which is 1,350 pills. And, so they had that history right there. They're pharmacists. They know that these are opioids, and the highest dosage of both kinds of prescriptions, the Xanax and the hydrocodone, or the oxycodone, and they know that there's a propensity for addiction in these. So, Dr. Dorn said that's a red flag to be able to look at that. And that's why they have a policy to verify every controlled substance prescription with the treating doctor. So, anyhow, we have Dr. Doran, who says, he's our expert. He says these are unreasonable on their face. They're unreasonable as to the quantity, the frequency, the combination. This could, he said the Xanax and the oxycodone could suppress the respiratory system. And he also says it's the 2-year period of the totality of things. Now they have an expert, Dr. Johns, who says something different, something contrary, but that's a conflict in the evidence. And that doesn't negate Dr. Doran's testimony. And so that's a fact question that should have gone to trial. Now, much was said in this case, below and in the answer brief that tries to discredit Dr. Doring, his credentials, but that goes to credibility and weight, and that's a fact question too. So that's not appropriate for summary judgment. And then Super Discount also asserts below that Doring only said that the March 24th and May 5th, 2011 prescriptions were below the standard of care. And as I earlier said, no, he said the back-to-back April 22 and April 23, 2009 prescriptions were also below the standard of care because Mr. McDaniel received essentially twice the prescriptions he should have received because they were one day right after the other, filled at 60 tablets. So there's that. And also Doreen said the history. So it's not just a question of these two or these 4 prescriptions that were made in 2011. And I think the judge must have resolved that inference against the McDaniels too. Also, there's a lot of comment about the Doreen standard of care that was below and also in the answer brief. And you know, Doreen testified that the standard of care is what a reasonable and prudent pharmacist would do under like or similar circumstances. And when he was asked about the Paul Doreen standard of care, he says, well, that's what experts do. We give opinions about what a reasonably prudent pharmacist would do. And he said, to the extent that I say Paul Doreen wouldn't have filled this prescription, that's just another way of saying a reasonably prudent pharmacist wouldn't do that because I'm a reasonably prudent pharmacist and I wouldn't do it. So he said they were interchangeable. So I think that's just a question of semantics. And I invite you to read his entire deposition, which starts in the record at 1868. And I know it's kind of lengthy, but the whole thing, he's not backing down from there's violations of the standard of care. And he's not saying this is a Paul Doreen standard of care. Once again, I'm used to a clock at the first DCA. So am I approaching the end of my time?
You have about 8 minutes left.
8 minutes of my 15?
Of your 20.
Okay, all right.
In 3 minutes, you'll be at your rebuttal time.
Thank you. Thank you, I appreciate it.
Okay.
So the verification, I think we already talked about that with Judge LaRose's question. And, we maintain that those magic words, Matthew's deposition said the verification has to say verified by, and then the name and the date. And it doesn't say that. His affidavit doesn't mention that. And of course, Super Discount Pharmacy doesn't mention those words either in its motion. But that's a conflict within his testimony, which the judge must have also resolved against McDaniel and in favor of the moving party. So that's another place where the standard was flipped. So I think when you consider the appropriate, the correct standard for summary judgment, the absence of any genuine issue of material fact, we have issues of material fact as to the unreasonableness of the prescriptions and the verification. And these are critical issues to the case. And so we maintain summary judgment was inappropriate and the case should be reversed and remanded for trial. On issues 2 and 3, I'm just going to briefly say, I'm relying on I'm not waiving them. I have argument in my brief and I'll rely on them, but I'm going to say this is another instance where the judge seemed to have flipped the standard, the summary judgment standard, because the Hall versus Talbot case talks about exactly the situation where affidavits maybe have deficiencies in them and where a party moves to amend them or supplement them to correct deficiencies. And that case says the liberal construction that you give to a non-moving party in summary judgment applies in the rehearing stage and also in the amendment stage for affidavits. So at trial, they'd be able to ask questions to correct deficiencies. So they should be able to correct affidavits to fix deficiencies. So here, we have our three doctors were struck, and we maintain that that's a strict construction against the non-moving party, whereas Mr. Matthew was not struck, which was a strict construction against the non-moving party. So it's a flip of the standard right there. And I think that it's important to note, Super Discount said that that these doctors were trying to impose a medical standard against Super Discount. but they're offered to show that these prescriptions are unreasonable on their face, which goes to the element of breach. And it's also interesting to note that Super Discount is using Dr. McNichols, another physician, to say that these same prescriptions are not unreasonable on their face. So I don't think they can.
Ms. LaCosta, let me ask you, is it your position that if in fact the pharmacist did verify the prescription with the doctor's office, that this is the amount, this is the date, this is what I prescribed, would that be sufficient to discharge their obligation, or are you of the opinion that something more would have been required?
Well, yes, I think a little more, because Dr. Doring also said that he was really concerned. You know, these prescriptions are monthly, you know, they don't come for refills. That's what I understand. And you know, Mr. McDaniels had his prescriptions in March, and then he didn't come in April, and then he came back in May. And Dr. Doring said, I would have wanted to know where he was in April. This is all in their history. And, you know, there's all these contracts that people signed for opioids. Was he getting opioids someplace else? That's a concern. And also there's testimony from I think it's Dr. North in the record in his deposition, where he says, you know, he went to rehab, and maybe Super Discount didn't know that, although the doctor's office was called, but they said if he went to rehab and got off opioids, then his tolerance level would have been way less. And that could happen in as little as a month. So if he were to start back at the same levels of opioids right away, which is exactly what happened, he could OD on that. And so I think that there is some sort of inquiry that maybe the pharmacist Bloom would have made, in addition to just verifying the robotic date, amount, did you really mean to do this? He could have asked those questions, and maybe Dr. McNichols would have scratched his head and said, gee, I didn't know that he missed in April, and I'd need to contact him. And maybe he would have never prescribed it then.
All right. And I let you go a little extra since I caused the problem. So you got about I'll give you your full 5 minutes rebuttal.
Oh, thank you for your generosity. I appreciate it.
My pleasure. Apolline?
May it please the court, Tom Valdez for Super Discount Pharmacy. Your Honors, it's our position that the prescriptions at issue in this case are not unreasonable on their face. Dr. Doring, in his testimony, as I pointed out in my brief, had no issues, said he had no issues with prescription filled in 2009, 2010, or February 2010. He only had concerns regarding the March 24th and May 25th, 2011 prescriptions filled by Super Discount Pharmacy. There was some mention of April prescriptions, but Super Discount Pharmacy didn't fill any prescriptions in April. So the reason that we're focusing on these prescriptions in March and April are because that's where their expert has focused. And Dr. Doring, Dr. Doring gave a lot of testimony during the course of his deposition. It was a sort of a typical deposition. It went pretty long. He said a lot of things, but the things that he said towards the end of his deposition on cross-examination negated the opinions that plaintiff appellant is now trying to use to advance his position on appeal. As I talked about in my brief, Mr. Doring said that he knew physicians who prescribed 30 milligram and 50 milligram oxycodone together, where one strength was used for intense pain and the other for less intense pain. That's exactly what these prescriptions say on their face, that one was for regular use, one was for breakthrough pain. Dr. Doring also testified there's no black and white rule that prohibits these medications from being dispensed together, and that there is legitimate reason to prescribe oxycodone in this manner. So he did, to your point, Judge LaRose, he did testify that there was a therapeutic use for this medication, and there was a reason for it to be prescribed in this manner. Dr. Doring admitted that reasonable pharmacists—
But generically, generically there may be a reason for the two medications, the two dosages, but wouldn't you have to go into more detail as on a per patient basis?
Well,
would that be a responsibility of a pharmacist?
Well, Your Honor, I think that the sort of the generic rule is what we're talking about when we say is something unreasonable on its face. These prescriptions are not unreasonable on their face, and Super Discount Pharmacy, to the extent it had a history on this gentleman, saw that his doctor was prescribing in these amounts, and our position is that this was verified with the doctor. And in fact, Dr. McNichol, who is the person who last examined Mr. Doring, went through his medical history, concluded that this was an appropriate, this was an appropriate medication regimen, said, if anybody had called me personally, I would have told them that this was absolutely appropriate in this case. So our position is these prescriptions are not unreasonable on their face. And if there's any question regarding the reasonableness of the prescriptions in this particular case, that red flag, that's the term used by Dr. Doring, was resolved by Super Discount Pharmacy, was resolved by Mr. Bloom. And again, Dr. Doring, getting back to what Dr. Doring said, he admitted reasonable pharmacists could dispense the May 25th, 2011 prescriptions without deviating from the standard of care. And he said that in uncertain terms. He answered yes. And he repeated the testimony at different points, and he repeated that testimony. He didn't just say it once. As I note in my brief, there are a couple of instances where he says it, and ultimately, Mr. Doring's testimony suggests that the pharmacist in this case may have handled things differently than he would have, but he conceded that reasonable pharmacists could disagree with them or disagree with him, that reasonable pharmacists could fill these prescriptions without deviating from the standard of care. And it's our position that's exactly what happened here. Now, it's easy, just to take a step back, it's easy in 2020, knowing what we know about the opioid crisis that unfolded over the years, to look at things and try and judge looking back by that standard. But the fact of the matter is, there was not even a prescription drug database until September or October 2011, after this gentleman passed away. So there's a limitation on what the pharmacists can do. The pharmacists can call the doctor and verify a prescription, and they can draw a line through the prescription and sign their name across that prescription to show that they have followed the policy. And Mr. Matheru testified that it was the routine policy of the pharmacy to verify any of these prescriptions. So now we're kind of getting into the second point.
Would you address, if you would, sir, Ms. LaQuasto's concern that the verification on the script was deficient?
Yes, sir. At one point in her argument, Ms. LaQuasto talked about semantics. And I think that's what she's getting into when she talks about the words verified by and describes them as magic words. Both the stated intent of the policy and the spirit of the policy that was in place at Super Discount Pharmacy was to assure verification of potentially problematic prescriptions. And there's no other reason for a pharmacist to put a slash through a prescription and sign and date his or her name there other than to check, to comply with this policy, to show that they've checked the medications. That just doesn't happen normally. And this is consistent with, and Mr. Matheru testified, he consistently saw Mr. Bloom verify prescriptions and note his verification of prescriptions in this way over the years. So, you know, that the absence of the word verified by don't change the clear, you know, the clear nature of the policy, spirit of the policy. They don't change the fact that there's clear, you know, that the drawing of a line through the prescription and the signature and dating of that prescription by the pharmacist is showing that they're complying with that policy. Hey, I looked at this, I checked this, and here's how I'm showing my assent. Using magic words, as the court knows, in various settings, using magic words tends to create bad law, tends to get us in trouble. That doesn't negate what you know, what Mr. Bloom did, what Mr. Matheru saw him do, him and the other pharmacists, including Mr. Matheru, do, or what Mr. Matheru did at Super Discount Pharmacy over a period of time. He worked with Mr. Bloom for about 7 years and saw him comply with this policy repeatedly. So that doesn't, again, we're back to, you know, circling back to my first point, these prescriptions are not unreasonable on their face, particularly in 2011, the summer of 2011. And that's where really the analysis should stop here, because Mr. Doring's testimony is equivocal. He equivocated, and that doesn't create a basis for finding an issue of material fact, not where Dr. Johns says very specifically, and he's a dispensing pharmacist, says that's not, you know, that's not a deviation. His testimony, Dr. John's testimony, actually matches up with Dr. Doring's testimony when he said, after, you know, at the end, when he says, well, I actually know there's a therapeutic use for this, and I actually know doctors who prescribe it. I actually know prescribing pharmacists who could fill this prescription without deviating from the standard of care. His testimony is lining up with Dr. John's testimony. You know, there may be some disputes in this case. We see this a lot in summary judgment cases, but there are no disputes of material facts. On material facts, the testimony experts line up. On the material facts, the testimony lines up that as a fail-safe, these prescriptions were validated, and there's not a shred of evidence from the plaintiff to contradict the testimony, to contradict the evidence that shows Super Discount Pharmacy through Mr. Bloom verified these prescriptions. As far as the other issues go, like Ms. LaQuasto, I'll address those only briefly. The affidavits of the doctors, medical doctors that were filed sort of on the eve of the hearing, I think is a pretty clear indication that plaintiff's counsel below said, gee, Doring didn't do us any favors here. Let's try and file these doctors' depositions that say, you know, these prescriptions are unreasonable. But a doctor and a pharmacist are two different things. They're licensed under 2 different chapters. There are different standards of care that apply to them. I lay that out in my brief in pretty significant detail. So they're you know, they may be experts in their areas, but they're not pharmacy experts, and their affidavits were properly, were properly stricken. And Mr. Matheru had both individual and institutional knowledge of Super Discount Pharmacy's policies and practices, what its employees, including Mr. Bloom, did. And so his affidavit was appropriate under the circumstances. Are there any other questions from the panel? In the absence of any questions, any additional questions from the panel, we'd ask that you affirm the trial court's grant of summary judgment, final summary judgment in this case. Thank you, Your Honor.
Thank you, counsel. Mr. LaQuasto, you have a 5-minute rebuttal time.
Thank you, sir. Just Mr. Valdez saying, I direct you to the actual testimony Dr. Doran said about which prescriptions he was concerned about. And that's in the record at 1941 through 1942. And the question kind of left some out. He said he had no problems with June 9, 2009, September 20, 2010, December of 2010, or February of 2011. But he did have problems with March 24 and May 25th, 2011, as well as April 2009. So when that question was asked of him, those April ones were left out. And Dr. Doran said, that's the back-to-back 60 tablets, which he said could never be resolved by conversation with the pharmacist. So it's not just those ones, it is a whole, and he did repeatedly say it was a whole history. So, you know, as to his standard of care, you know, argument, yes, he admitted that there was room for a reasonable pharmacist to disagree, but that doesn't obliterate the standard. It just says it's maybe not as exacting as that applied in medical malpractice, but you still have to use due and proper care. And there still is a standard of care. And he still did say that it was violated in April, in 2011, in 2009, in 2011, and also by the history of it. And, you know, I understand that the database, you know, didn't exist until this passage of this 2011 law, but Super Discount had the history there in their own information. So they knew that the history, they could look back at it. So it's not like they can't look and see if he's shopping all over the place because there's no database, but they can look and see their own records. As to the verification, you know, it's not our burden it's not our burden until they have presented, they've shown that there's no genuine issue, absolutely no genuine issue of fact. And here, there's a conflict between Matthew's affidavit and where he says, you know, it's 1838. It starts at 1838 and 1839 in the record. The question is, what you would exactly write? Do you recall what you would exactly write on the prescription, on the face of the prescription? And it says, the answer is, quote, verified by the name of the person who has verified the prescription. So it's not there. That's a conflict. That precludes summary judgment. This verification is critical to this case. And we're supposed to be construing under summary judgment all these facts in favor of the non-moving party. It just wasn't done. So, so I think that's a fact question and precludes summary judgment. Any other questions? I think I chipped off everything on my list that I wanted to say.
All right, I think that does it. Thank you very much.
Then I'll ask you to reverse. Thank you so much for oral argument and have a great week.
You too, counsel. Take care.